2020, and this is the claim that was made during this period. Sorry, just 1 minute. I am told that the screen is not visible. Let me just ensure my screen is visible. I hope you can see my screen now.
Yeah, it is visible, sir.
Can you view the screen now? Sorry, just 1 minute, please. I'm sorry for that. Just 1 minute. I'm sorry that there seems to be some technical difficulty, so kindly pardon us for not sharing the PPT, but we will share the PPT to you once the program is done. In South Korea, the government sought to increase the weekly hours from 52 to 69 hours. So it's something that the younger generation of the country felt that the work-life balance would be affected, and they wanted to reconsider, the government to reconsider and cap it back to the 52 hours. Whereas if you look at in India, Karnataka government has brought in where you could make a 4-day week with 12 hours, and so the total will be only 48 hours. In any event, our working hours are much less, but we are looking at a 69-hour week in South Korea, and that has had a backlash from the citizens of the country. With the NEEM scheme being revoked by the government, there's a lot of query on engagement of apprentices and trainees. Therefore, we thought we would this month look at the knowledge corner where laws on engagement of apprentices and trainees. First, where do you get the power to employ a person as an apprentice or trainee? One, it could be under the Industrial Employment Standing Orders Act because it provides for apprentices. Two, the Apprenticeship Act 1961. These are the two places from which you could derive the power to employ somebody as a trainee or apprentice. So, and under the Apprenticeship Act, the government has formulated various schemes like NATS, NAPS, board, etc., where you can engage people as apprentices. As far as standing orders is concerned, you could engage based on a training scheme that you may formulate. Apart from it, today we also have schemes of earn while you learn, where things are going on. There many queries have come on PF and ESI. I would say it's still a gray area. I do not want to make any comment on it at the moment. Yes, it is possible of engaging people under earn while you learn model as well. But we thought we should just make you aware of the various legal provisions in this regard. To start with, the Factories Act 1948 defines only the term worker, and it is very wide to include all kinds of persons, including an apprentice and trainees, could also come within it, because remuneration is not a must for the definition of a worker under the Factories Act. So where does it take you? Yes, earn leave is only after 1 year, but in any event, whether they will be entitled to earn leave over time are to be paid even to trainees would be a next question. If you're only a trainee, why are they required to do overtime work? So the nomenclature itself will have a trouble otherwise for other issues, like if an industrial dispute is raised. So employers need to ensure that the trainees or apprentices are not utilized for overtime work. The ESI Act was amended in 2010, and after the amendment, except for an apprentice under the Apprenticeship Act, even a standing order trainee or apprentice would need to be covered under the provisions of the ESI Act. The EPF Act excludes apprentices and standing orders of the employees under the standing orders of the establishment. That's the definition of employee for Provident Fund. But practical purposes, when an officer of the Employee Provident Fund organization chooses to question, was that person really given training? You designated him as trainee, but was he imparted with training? You would need to justify, yes, he was imparted. In such cases, you don't need to pay PF. But the safer approach employers tend to take today is that irrespective of them being trainees, Provident Fund being extended to such persons. Bonus Act will not have much implication on these persons. It may not apply to them because specifically apprentices are excluded. Minimum Wages Act is concerned, the government has the power even to give a legislation or fix rates of minimum wages even for trainees. In fact, Tamil Nadu government, for instance, has fixed rates of a stipend to be paid for trainees in respect of 3 scheduled employments as on date. So the government can fix. A safer approach once again here is even if the government does not fix the lowest unskilled as a stipend for trainees. Fixed term employment would come in. We will touch upon this topic much later when we look at another citation that we will be seeing in the judgments segment. So there are many schemes. The NEEM was one such one which has now been discontinued. And as we already discussed, it is said that no fresh enrollment, but the existing enrollments can continue. In the Did You Know segment of this month, we just wanted to point out that state governments have taken the clue and have started to extend menstrual leave for women employees. Kerala was the first one, followed by Bihar. Bihar followed by Kerala and quite a few other state governments. And the Kerala government, in addition, has decided to give maternity leave even to students. So if you're a student and you get pregnant during your course, up to 60 days of leave is being granted even to students. In the case law corner, this is a case where Provident Fund authorities failed to serve the summons and orders to the employer. It was being sent to the old address despite Provident Fund being made aware of the fact that the employer has moved to a new address. The courts felt that it is not sufficient service and therefore was pleased to grant staying, saying that the employer was not served in the proper address. The next is a case pertaining to trainees, an engagement of trainee. The employee concerned was initially offered training in the year 97 and was extended, and he within the period of 3 years he was there, and the labor court dismissed. And of course, this is one-off case from the Gujarat High Court, where it said that he was aware that he's only a trainee and there's no violation of any provisions of the ID Act. So wherever you have any kind of disputes being raised by trainees, this judgment can be relied. And it's quite a useful judgment that's come recently from the Gujarat High Court. In our Lex Posh segment this month, we are looking at a case where a woman employee was filed a complaint against her principal. It's a school, and the case was that she was being harassed. But the courts concluded that there was no harassment and merely being asked to do a procedure laid down by the management, for instance, with regard to application of leave. If the employer were merely asking the employee to follow a procedure that has been contemplated, the same cannot be said to be a sexual harassment. It's a case where this employee went across in different places. So she went with the criminal court, she went before the state commission for women, and she was trying to rope in the petitioner, and she was trying, and the courts concluded that she's not been able to prove anything, and in fact, it's a case where she had harassed the person, and it's not the other way around. To conclude with our quiz question, the answer would be 50 employees. The Maternity Benefit Act does not look at women or men. It requires only 50 employees put together. Whereas under the Factories Act, it is 30 women. So this would be applicable even to a factory. And therefore, it should be ensured that wherever there are more than 50 employees, a crush facility is maintained. In the complaints corner, we have the usual complaints. You could have a look at the slide when we share the PPT with you. We have a program on 11th under the Lex Posh, where we have an IC Posh, a specialized training program for 1 day. We hope to connect with you again next month. Thank you for joining us this month. Thank you.